Be ready. 5 seconds.
The concerns which have arisen during the course of hearing the present appeals are of particular significance for meeting the ends of criminal justice, and relate to the nature of charge sheets filed in some jurisdictions by the state/police. For the sake of convenience, we would divide the judgment into two parts. The first part relates to the legal issue, that is, the contents of the charge sheet in terms of section 173(2) of the Code of Criminal Procedure. The second part deals with the factual aspects of each of the cases, and our decision. The issue in the first part relates to charge sheets being filed without stating sufficient details of the facts constituting the offense or putting the relevant evidence on record. In some states, the charge sheets merely carry a reproduction of the details mentioned by the complainant in the first information report, and then proceed to state whether an offense is made out, or not made out, without any elucidation on the evidence and material relied upon. The decision refers to section 157 of the code, which inter alia states that, if on information received or otherwise, an officer of the police station has reason to suspect commission of an offense which he is empowered under section 156 to investigate, he shall forthwith send a report of the same to the magistrate empowered to take cognizance of the offense. Further, he shall proceed in person or depute any of his subordinate officers to proceed to the spot to investigate the facts and circumstances of the case, and if necessary, to take measures for discovery and arrest the offender. Such report is in the nature of a preliminary report. As per section 169 of the code, if it appears to the officer in charge of the police station that there is not sufficient evidence or reasonable ground of suspicion to justify forwarding the accused to the magistrate, then the officer shall release the person if he is in custody on his executing a bond, with or without sureties, with a direction to such person to appear, if and when so required, before the magistrate empowered to take cognizance of the offense from the police report. Section 170 of the code deals with the cases where it appears to the officer that there is sufficient evidence or reasonable ground to proceed. In such an event, he is required to submit a police report or charge sheet under section 173(2) of the code. In Tara Singh versus State, the question which had arisen was whether the challan preferred by the police was complete so as to enable the court to take cognizance. It was held that a challan submitted in the said case was complete except for submission of the report of the imperial serologist and drawing of the sketch map of the occurrence. In this context, reference was made to section 173(1) and that the report/challan should set forth, viz. the names of the parties, nature of the information and names of persons who appear to be acquainted with the circumstances of the case. Stop. The cognizance, it was held, was proper. Stop para. In R.K. Dalmia versus Delhi administration, again a reference was made that the charge sheet must contain name of the parties, nature of the information, and the names of persons who appear to be acquainted with the circumstances of the case. Stop.